Hello and welcome to the second module of our training tool on strategic litigation for professionals working with destitute EU migrants. This is a series of 6 training modules on strategic litigation in EU free movement cases, which is designed for professionals working to promote and protect the rights of destitute mobile EU citizens. In this second module, we will take a look at how Member States engage in measures which restrict EU free movement rights. This will help to set the background for the subsequent modules looking at different forms which strategic litigation can take. The right of free movement of EU citizens is not completely unconditional. It is subject to conditions. For example, when staying in an EU country for more than 3 months, in order to have a right to reside there, an EU citizen must work, or, if they do not work, they must have sufficient resources so as not to become a burden on public finances. As a matter of EU law, Member States are therefore sometimes lawfully entitled to restrict rights of residence of EU citizens and their family members. The first ground on which residence rights may be restricted is when a person does not meet residence conditions, or, after initially having met those conditions, that person no longer does. A second reason for restricting residence rights is when an EU citizen becomes an unreasonable burden on social assistance. A third legitimate ground for states to curtail residence rights is when a person engages in conduct which is contrary to public policy or public security. A final ground for taking action against the residence rights of EU citizens is when they commit fraud or abuse. In practice, the majority of decisions tend to be taken on the grounds of a person not meeting or no longer meeting the conditions relating to residence rights. For a detailed discussion on the circumstances when Member States are entitled to take action, please do take a look at Module 4 of the EU Free Movement Guide, which covers the grounds for expulsion of mobile EU citizens. A link to this resource can be found on the list of useful links included below this video. There are several examples of the kinds of measures which the national authorities might take to restrict the free movement rights of EU citizens and their family members. A restriction may include a decision to refuse to issue residence documentation. For example, a refusal may be taken on the grounds that EU citizens or their family members have not provided sufficient proof that they meet the conditions for having a right of residence. A restriction may also include a decision to terminate or withdraw an existing right of residence. For example, a decision may be taken to terminate residence rights because a person commits a serious crime which is considered contrary to public policy. Another kind of restriction involves a refusal to award social assistance or social security benefits. For example, when a person is refused access to a minimum income guarantee because this is considered as creating an unreasonable burden on public finances. A further example of a restriction consists in refusing equality of treatment to EU citizens and their family members. For example, when a child of an EU worker is refused the right to access school under the same conditions as apply to children who are nationals of the country concerned. In some cases, the restriction will comply with the EU rules on the free movement of persons. In other cases, the restriction may be imposed because of a restrictive interpretation of key concepts found in EU law. So, for example, in accordance with EU law, someone is considered a worker if they provide services to another person under their supervision or control, and in exchange for which they receive a salary or payment in kind. When someone is considered a worker as a matter of EU law, they will have a right of residence without being required to demonstrate that they have sufficient resources so as not to be a burden on social assistance, and that they have healthcare insurance cover in place. However, the national authorities sometimes follow a restrictive approach as to who is a worker and impose additional conditions which are not required under EU law. For example, they may impose a minimum income requirement and exclude workers who might be on a low income. Or the national authorities may require a person to demonstrate that their employment contract will run for a certain minimum period of time and exclude workers who are on fixed-term contracts. Alternatively, the national authorities may refuse to consider that someone is a worker if they work for only a few hours per week. This restrictive interpretation of key concepts in EU law may therefore form the basis for strategic litigation. Another way that member states restrictively interpret key concepts of EU law relates to job seekers, or those who have retained the status of worker under EU law following a break in their work. So, for example, the national authorities might allow a first-time job seeker a period of less than 6 months to find work, which would be unreasonably short. Or if someone has become unemployed, the national authorities may refuse to recognize that they have retained the status of worker under EU law, because they consider that the duration of their prior employment is too short, for example, because they only worked for 2 weeks. Still, in other cases, the national authorities might interpret the concept of genuine chance of being engaged in a very narrow way. This is a concept which has been developed in various judgments of the European Court of Justice to decide that, in a situation where someone has not found work after 6 months, this person may still be allowed to continue looking for work, provided they can demonstrate they have a genuine chance of being engaged. So, for example, the national authorities might refuse to accept that undertaking additional professional training or completing language classes are ways to promote a person's chances of being employed. Again, these are further examples of key concepts of EU law being interpreted restrictively and which may be appropriate for strategic litigation. For further examples of the key concepts which relate to EU residence rights, please have a look at Module 2 of the EU Free Movement Guide entitled Status for Legally Residing, in which covers the conditions that EU citizens must meet in order to benefit from a right of residence. A link to this resource can be found on the list of useful links included below this video. In the particular context of homeless mobile EU citizens, the Member States have in recent times exercised their powers to penalise homelessness under the EU free movement rules. For example, some Member States consider that EU citizens who are homeless constitute an unreasonable burden on social assistance when they have recourse to social assistance programmes which aim to help the homeless. In some countries, EU citizens who access shelters may subsequently find themselves the target of action by the national authorities to terminate their residence rights. In other countries, the national authorities have ordered the removal of EU citizens who are homeless on the basis that they are engaging in an abuse of rights. However, this practice was struck down by the English courts when the UK was still a member of the EU. Another example of how member states have targeted homeless mobile EU citizens is by criminalising begging or encampments. EU citizens who are prosecuted for these offences then face removal from the country on the basis that their continued presence would constitute a threat to public policy. The pursuit of a restrictive interpretation of key concepts of EU law by the national authorities are just some of the ways in which member states make it difficult for people to exercise their right to free movement in the EU. There are many other examples of obstacles which EU citizens and their family members face when moving within the EU. These have been the subject of recent extensive reports, including a study on obstacles to free movement by the European Citizen Action Service and a set of policy recommendations published by FEANTSA and its partners. A link to these documents can be found on the list of useful links included below this video. We will now engage in a practical exercise. Please consider this situation. You are working as an advisor for Focus Ireland. You receive a call requesting assistance from Günther, a German national living in Cork, who has been told he's about to lose his job. He fears becoming homeless. He wants to know whether he is entitled to claim job seekers allowance. He is afraid of making a claim because he's been told by colleagues that he might be ordered to leave Ireland if he claims this kind of unemployment benefit. Günther wants to know if claiming job seekers allowance may lead the Irish authorities to terminate his right of residence. What would be the most appropriate course of action to advise Günther to take? Is it 1. Günther should be advised not to claim job seekers allowance? 2. Günther should be advised to bring an appeal before the Irish courts? Or 3. Günther should be advised that you can help him obtain free legal advice by contacting the European Commission's Your Europe Advice Service? The correct answer is 3. Günther should be advised that you can help him obtain free legal advice by contacting the European Commission's Your Europe Advice Service. Günther should not be advised not to claim job seekers allowance, as on the face of it, he may have a valid claim after working in Ireland. Gunter could not bring an appeal before the Irish courts as no decision has been taken by the Irish authorities that could be appealed. Your Europe Advice is a free advisory service of the European Commission. It provides information to individuals who need help in exercising their rights under EU law. Inquiries can also be made by non-profit organisations that provide help to mobile EU citizens. Your Europe Advice is staffed by around 60 legal experts who provide free and personalised advice in the language of the person's choice. The service aims to clarify the European rules that apply in the person's case and explains how they can go about exercising and enforcing their EU rights. The service may also be used by civil society organisations. An inquiry can be made online or by telephone, and a reply is provided within a week. This second module may be viewed alongside the related training video entitled EU Free Movement Guide, which is available on a list of useful links which should appear below this video. Further useful resources are also included. This concludes our second module, which sought to provide an overview of how Member States engage in measures which restrict EU free movement rights. Thank you for your attention.